Good afternoon and welcome to Noble Consulting Services semi-annual ethics webinar. My name is Rick Nelson, and I would like to welcome you to our session today. We have a very dynamic speaker today for our 1 hour ethics session. Before I begin, a few housekeeping notes. First, this webinar is being recorded, and the recording can be emailed upon request for on-demand viewing. If you do have any questions during the webinar, please use the Q&A feature. We'll try to answer as we go, but if we can't respond live, we'll follow up with you afterwards. Don't forget to include your name when submitting your questions so that we know who to contact. This webinar qualifies for 1 hour of Ethics CPE. We are using the Conference IO platform to track attendance. Please log in using the QR code shown on the screen or navigate to the Conference IO webpage using the address provided in the first bullet point and choose Noble Spring 2026 Ethics Training Session. You can access Conference IO either on your phone or on your computer. You will first check in and then enter the code numbers that will appear in the slides throughout the presentation. You must attend the webinar for at least 50 minutes of our 1 hour session and enter at least 3 of the four code numbers into the Conference IO app to receive full credit. Please remember to check out in the Conference IO app at the end of today's webinar, and then our CPE certificates will automatically be emailed to you directly from our learning management system in the next few weeks upon completion. Right, I'll leave this up for just a little bit longer here, but I'm pleased to introduce today our speaker, PG Sittenfeld, for today's session. PG is a writer and speaker with a very interesting story. His journey took him from Princeton University to politics to prison to Supreme Court petitioner. Today, he is a writer whose recent work has appeared in the New York Times, the Washington Post, the Free Press, and Esquire and American magazines. He regularly gives talks to top U.S. schools, firms, business clubs, and trade associations. So I'll let PG continue with his background, personal story, and message of ethical implications. And please welcome PG Sittenfeld. Thank you.
Great. Thank you so much to Rick Nelson, to Jim Cotman, to the Noble and the KSM teams for the invitation to join you all today. As Rick said, just a little bit of housekeeping. I will make sure to pause at 2 different junctures so that you all can scan the QR code to make sure that you get your credit. Today, we're going to be using the wild and extraordinary backdrop of the FBI sting operation that targeted me, as well as my subsequent jury trial, imprisonment, presidential pardon, and ultimately Supreme Court victory to explore critical inflection points where intentions and ambiguity could have been resolved and clarified, potentially yielding a very different outcome. While the story that I'm going to be sharing today unfolded in the arena of campaigns, politics, city government, and law enforcement, I believe the lessons are absolutely applicable for insurance regulators. And I hope at the end to add a few tools to your toolkit for helping maintain professional integrity in high stakes environments. But before we get to those lessons and learnings, you can first settle in for a truth is stranger than fiction backstory. If you were to rewind my life several years, I never could have imagined that I'd have become a criminal defendant and experienced an intense and high-profile 3-week jury trial, and that for 4.5 months until the day of my dramatic and very unexpected early release by a panel of 3 federal appeals judges. I'm just seeing a comment. If it's echoey or anything else, someone can ping me on the tech. Otherwise, I'm going to keep proceeding. Then until my unexpected and early release from prison by a panel of 3 federal appeals judges, I was federal inmate 18085-509 at a correctional facility in Ashland, Kentucky. I could never have imagined that a year after my very surprising early release pending appeal, I'd then receive a full and unconditional presidential pardon and become the first person who, after having that occur, still move forward petitioning the U.S. Supreme Court. Among so many astounding facts about my case is that the Attorney General of the United States under President George H.W. Bush, President George W. Bush, President Donald Trump, the White House counsel under President Barack Obama, and so many others all submitted briefs to the court saying that this isn't right. No crime was committed here. So, how did this all happen and how did things go so wrong? Let me take you back now to how this surreal legal saga got started. After growing up in Cincinnati, Ohio, attending Princeton University for college and then Oxford in England for graduate school, and working for an education nonprofit, I ran for and entered elected office at a young age where my twin priorities as a Cincinnati city councilman were always boosting economic development and job growth in our city and also trying to look out for the most vulnerable members of our community. In February of 2018, a former Cincinnati city councilman asked me to meet with two men whom he described as out-of-town investors looking for projects in the city of Cincinnati. As a member of the city council, then in my third term, this was the sort of thing that I did all the time, always viewing it as an opportunity to encourage people to be part of the city's unfolding renaissance. I met with those two out-of-town investors early on a Monday evening for less than an hour. It was mostly informal and introductory because they didn't yet have a specific project that they were proposing to me. There was zero mention of campaign donations by them or by me. And before we parted ways, I said the same thing to them that I said to everyone I met with, whether they were rich or poor, black or white, lived in Cincinnati or were visiting from out of town. If I can be helpful with anything, don't hesitate to reach out. Never in a million years could I have imagined that those two men were undercover FBI agents unfurling a dragnet across Ohio, looking for public corruption across the state in its cities, both large and small. Now, I'm going to be able to share direct dialogue with you today because almost all of the key interactions were recorded by the FBI and later played in court. And also, of course, because I was a direct participant in those interactions, so I have my own corroborating recollection of all of the events. Now, even before meeting those undercover agents posing as real estate investors, I had supported the revitalization of an enormous blighted building in the heart of downtown Cincinnati, directly across from our region's main convention center. And the property is actually referred to by its address, 435 Elm. In addition to 435 Elm being dangerous and an eyesore, it was also costing city taxpayers $400,000 a year in maintenance and upkeep. So across my nearly decade of service at City Hall, there were a number of times I needed to make difficult decisions, face tough calls. This was not one of them. Supporting the redevelopment of 435 Elm was a total no-brainer. About 8 months after that otherwise forgettable first interaction with the undercover agents, our paths were intentionally set up to cross again. A friend of mine at that time named Chinedum Ndukwe, a former NFL player for the Cincinnati Bengals, who then gone into real estate development after retiring from football, had purchased the air rights to the 435 Elm property, and he wanted to lead its redevelopment. And Ndukwe, whom I called Chin, told me that he had two investors backing the 435 Elm project whom he also thought would want to be backers of my upcoming mayoral campaign, in which I was widely regarded as the most likely candidate to win. What I did not know, what was not publicly known to anyone at that time, was that earlier that same year, so 2018 in our chronology, Chin had signed a proffer agreement with the feds outlining his illegal conduct described in the proffer as, quote, criminal activity related to structuring banking transactions, money laundering, and aggravated identity theft, end quote, from his proffer agreement with the federal government. Right around that time, Chin agreed to become a cooperating witness of the FBI. For almost a decade before that, as I mentioned, we had been friends, and during that time, he had been a proactive and enthusiastic donor to almost all of my political campaigns. I could never have imagined that in 2018, he began to wear a wire during all of our conversations. Or I'm going to jump ahead in our timeline for just a moment. As the U.S. Sixth Circuit Court of Appeals judge would subsequently write in a majority opinion from just a little over a year ago, quote, all of the major players except for Sittenfeld, were working for or with the government. That is, these were paid actors working to incriminate Sittenfeld, end quote from U.S. Court of Appeals Judge John Nalbandian. During one of my recorded conversations with Chin in the fall of 2018, he told me that his out-of-town investors on the 435 Elm development, whose fictitious names were Rob and Brian, of course, I believe those to be their real names, not knowing of the fiction, said that they wanted to make $10,000 in campaign donations to me. For context, by that point, I had already raised about $1 million in my campaign account. But Chin added, relative to the 435 Elm project, they'd want to know that, quote, it's going to be a yes vote without a doubt. Despite in no universe ever fathoming that I might be on a wire, I immediately said, obviously nothing can be illegal. Nothing can be a quid pro quo. And I know that's not what you're saying either. End quote from me. I then immediately reminded Chin of my long held policy views. Quote, what I can say is that I'm always super pro development and revitalization of especially our urban core, end quote. While Chin's comment sounded odd to me, he was both a real estate developer in good standing in the community and an old personal friend, and I tried to immediately give him the benefit of the doubt. Chin proceeded to arrange a lunch with him, me, and Rob. And when it was initially being set up, I didn't realize that Rob was one of the two guys I met briefly the prior February. And I actually only put that together when I saw him at the lunch in person. At lunch, the three of us talked about the 435 Elm project, and I asked various additional questions to keep vetting it. As lunch concluded, Chin said that he needed to take off, and Rob asked if he and I could continue the conversation at the apartment that he was renting across the street. Sadly, only in retrospect would I learn. This is what a highly choreographed sting operation looks like. A lunch gets set up by a cooperating witness who, unbeknownst to anyone else, became a cooperating witness under the hovering threat of facing his own prosecution. Because of an existing relationship with a cooperating witness, taking such a meeting feels natural and normal. The cooperating witness then departs early, and the undercover agent asks you to join him at his penthouse, which conveniently is right across the street. During our brief time together in the penthouse, when Rob talked about the 435 Elm project, I asked more questions about the project and continued to share my belief in the project's merits. When Rob brought up political donations, I responded with instructions on how he could make a lawful donation. When he attempted to provide a campaign donation in cash right then, because you are allowed to donate cash to a candidate's campaigns, but like everything, there are rules around it. I immediately called a campaign compliance finance expert on my staff to ask about that, and then declined to accept his offer. Much later, also at oral arguments, one of the Sixth Circuit judges, a U.S. Sixth Circuit Court of Appeals judges, characterized my and Rob's interaction as us talking past one another, like ships passing in the night. Now, something that has always, right through the present moment, felt mind-boggling to me was that in nearly 2 years of them engaging me in a sprawling and expensive sting, entirely dependent on establishing an unambiguous quid pro quo as the relevant statutes require, there was only ever one such quid pro quo articulated. It was proposed by Chin at the direction and scripting of the FBI, who were paying and controlling him as their cooperating witness, and my response was to immediately reject it. Please keep those interactions that I just narrated in mind, because we're going to come back to them during the lessons portion later. Now, because this case centered on lawful campaign donations, and because in no universe would I have ever personally tried to pocket money, the government never once alleged such a thing, this case was all about my intent. The government needed to prove my mens rea, as is the legal term. Again, later on, I'm going to be making a big deal about gaining crystal clarity around the intentions of the people that you are regulating. In my case, after the undercovers posing as investors made routine donations to my political action committee, I reported those donations in my next filing with the Federal Election Commission. Those contributions could be looked up by anyone at any time with just a few clicks on their computer. While meeting the undercovers posing as real estate investors in public and highly visible places around town, I would spontaneously introduce them to various other civic leaders that we ran into, and I offered to introduce them to many more. After all, I viewed them as people who wanted to back something that was indisputably good for our city. And perhaps the kicker regarding my intent is that 3 weeks after what the government would later claim was an allegedly corrupt agreement at that lunch and apartment interaction, I hosted at our home in Cincinnati a dinner party with four other couples as guests. One of those couples included the sitting United States Attorney for the Southern District of Ohio, that is the top federal prosecutor for the entire southern half of the state. During a phone conversation with the undercovers, I extended an impromptu invitation for them to come join at my home for that dinner, and I even mentioned that one of the guests would be the sitting United States Attorney. Now ask yourself when considering intent, what person who is trying to be corrupt invites their alleged co-conspirators to come spend the evening in his home with the very person who would prosecute him? If phase one of this elaborate sting was the government clunkily trying to conflate lawful political donations with my support for the 435 project, it seems almost certain they didn't have confidence that all their effort had yielded a very strong case, because they then set in motion an elaborate phase two. As a former top prosecutor in the Department of Justice's Public Integrity Unit told me, you would never take on the effort, the expense, and the risk of a prolonged sting if you truly believed you already had a winnable case. In phase two in 2019, the government brought in more undercovers. They provided additional PAC donations, none of which I actually ever asked for, and the undercover suggested taking trips together, which I declined. Part phase two of the sting yielded no line of dialogue or interaction that came remotely close to an unambiguous quid pro quo. And yet, in late November of 2020, 8 FBI agents came to arrest me in the driveway of my home. With that cliffhanger, I will pause for you all, or hand it to Rick for you all to do the second QR scanning.
All right, great. Thank you, PG. Um, the first code I had presented earlier, code number 2 is now on your screen. So please enter the second code in the Conference IO platform as well. Thank you.
And Rick, some comments are popping up, but that I can't really follow. Are we good on the technicals here?
Yes, we have IT monitoring those. Thank you. We're
Okay,
good.
great. Dive back in.
Yeah, please continue.
All right, so where we left off, my coming home to one of the most shocking days of my life, where 8 FBI agents arrested me in the driveway of my home. Now, because ethical situations can often be very high stakes, I also think it's important that I share with you today some of the human side of this story. On the day that I referenced, my amazing wife, Sarah, was in the midst of her medical residency in oncology at the Cleveland Clinic. So on that fateful morning, I actually drove, starting the day in Cleveland, back to Cincinnati in order to be arrested at my home. When I reached my driveway, the 8 agents all turned toward me, and one of the agents said, "Hi, PG," as he and another agent moved towards me. They then asked me to turn around to put me in metal handcuffs with my arms behind rather than in front of me. "We don't think you're a threat or a danger," one of the agents said as he latched a cuff over each wrist, "but we have to do this." As I would later be told by a variety of former prosecutors, an indictment is meant to be a highlight reel against the person being charged, attempting to overwhelm them from the onset into a guilty plea. Even though prosecutors had cherry-picked comments from me to try to make my words seem incriminating, as I sat in a U.S. Marshal holding cell reading the indictment for the first time, despite the dire and very shocking circumstance, my spirits actually improved dramatically. The biggest relief was reading in the indictment the conversation between Chin and me, where he'd said it would need to be a yes vote without a doubt, and I'd immediately said nothing can be a quid pro quo. I remember sitting in the U.S. Marshal holding cell that day and thinking, why did they bring this case in the first place? What's the real reason? I was released that same afternoon of my own recognizance, and more than a year and a half passed between the time that I was indicted and when, believing fiercely in my innocence, I chose to go to trial. As you would expect, and as I pray you never experience for yourself, it can be incredibly unnerving being a defendant. The visual image that's always come to my mind is you feel like you are strapped to a conveyor belt headed toward a buzzsaw. Your life, especially your professional life, is in limbo. Your reputation for the time being is getting battered, and you're very limited in how you can fight back and what you can say publicly. And your loved ones are terrified that they're going to lose you to a lengthy prison sentence. Now, I had the opportunity to avoid going to trial by accepting a plea deal, which even held the possibility of no prison time at all. Though I can tell you, it never seriously occurred to me to accept a plea deal because I simply could not fathom saying that I'd done something that I hadn't. I also realize that defendants do that in our system every single day to mitigate the potential punishment and because fighting can be financially ruinous. And even though it shouldn't be, it's not what our founders and framers intended. It's a privileged position to be able to fight for your innocence by going all the way to trial. And so in June and July of 2022, now in our timeline, for nearly 3 weeks, I sat as the defendant in the Potter Stewart Federal Courthouse in downtown Cincinnati. I'm not going to give you a complete play-by-play of the trial, though if you ever have the impulse to find the court transcripts and read them, I encourage it. In the spirit of making my full intentions as clear as possible, my lawyers and I asked that every second of every tape conversation that the government had made be played for the jury. After all, the government had chosen to concoct the whole sting. Why not give jurors access to everything? The government fought us on that point and prevailed. And in the end, jurors were allowed to hear just a tiny sliver of the recordings. The FBI's three main undercover agents and Ndukwe all testified, and I took the stand in my own defense for several hours of direct and cross-examination. During closing arguments, the lead prosecutor strikingly told jurors, quote, "This case is not about whether or not it was a good project or a bad project. It's not about whether the defendant is popular or liked or has got good ideas as a public official or whether he should have supported the project anyway. It doesn't matter." End quote from the lead prosecutor. What he did make very clear was that the six charges against me were deeply intertwined, with all of the counts being public corruption charges based exclusively on campaign donations and exclusively from within the context of their sting operation. July 8th, 2022 was a Friday, and it marked the third day of jury deliberations. I arrived at the courthouse with my family, and my wife Sarah and I walked into the courtroom together for what we hoped and prayed would be the last time. My lawyers were already seated at the defense table, and I sat in the chair between them. And I remember my heart racing and taking long, deep breaths to try to stay calm. "All rise for the jury," the courtroom deputy called out. And as the jurors that day passed by me, I mostly kept my gaze toward the ground, but the few expressions that I quickly glimpsed conveyed very little. The judge asked the jury foreperson to hand the completed jury form to the courtroom deputy, and the courtroom deputy began to read it. In a loud, clear voice, he read out the first charge. "How do you find the defendant, Alexander Sittenfeld, aka PG Sittenfeld, as to count one, guilty or not guilty?" And then he said, "Not guilty." In that moment, they were two of the sweetest words I had ever heard in my life, delivering a combination of relief, vindication, a feeling of freedom, and at that point, releasing more than a year and a half of built up emotion. I closed my eyes, and immediately tears of joy began to stream down my face. The deputy then read out the second charge, and then again, those two exhilarating, hard-won words, "not guilty." After hearing the first two acquittals and understanding how interwoven all six counts were, because they were all about my intent, I thought, dear God, it's going to happen. Six not guilties in a row. The courtroom deputy continued on reading the third charge. "As to count three, guilty or not guilty," and then guilty. The next three counts were guilty, not guilty, not guilty, meaning across the six charges, four acquittals and two convictions. By splitting the outcome across the 2018 counts, the exact same time period covering the exact same conduct, the jury, and this is their right, the jury was saying what was literally not possible, that my intent was simultaneously corrupt and also at the exact same time not corrupt. The fact that the jury had acquitted me on all three counts related to 2019 further underscored the confounding nature of the outcome. Part of prosecutors' core argument was the deeper into this sting PG got, the more he had to have known that these undercovers posing as investors were corrupt. And yet, through their verdict, the jurors found I did not believe the undercovers had corrupt aims in their dealings with me well into and at the end of the sting. The courtroom deputy saying guilty for the first time felt like a glitch in the universe, at least a glitch in my universe, not unlike when I first learned I was being indicted, the kind of event that is uprooting and disorienting because you know it's going to change the course of things forever after. As soon as the judge adjourned the hearing, I went straight to Sarah, my wife, wrapped my arms around her, and we ducked into a little side room off the main courtroom that we'd use during the trial. Well, Sarah and I were in that side room. We decided that my sister Curtis, who was in from out of town to be in the courtroom with me, would get her car from a parking garage and pull up directly in front of the courthouse. I said to Sarah, "Why don't you and your mom walk out separately from me so you don't have to be next to me while I'm getting hounded by reporters?" Of course, I preferred to walk outside holding my wife's hand, but I also wanted to try and protect and shield her, even if it was in the smallest of ways. "We will walk out together," is what Sarah said to me. And I want to say here that just as Sarah literally took my hand in that moment, so many people throughout this journey, family, friends, lawyers whom I didn't previously know, and whose only motivation has been truth and justice, have done the figurative version of taking my hand, collectively helping give me strength to take the next step. And their support, as well as my Catholic faith, have provided me with ongoing feelings of calm, resilience, and optimism, even in the midst of so much turbulence. Now, something extraordinary happened almost immediately following the trial. Three of the most respected law firms in the country each immediately reached out and offered to lead my appeal entirely pro bono, believing that the outcome had been a wrongful conviction, that it badly misconstrued the law, and that it set a dangerous precedent which could be a wrecking ball for the functioning of our democracy. The law firm of Jones Day took over the appeal because they believe that this case, I want to be clear, these are their words here, not mine, represents the single most extreme attempt to criminalize lawful conduct involving campaign donations in American history. In one of Jones Day's briefs to the court for my appeal, they described the government's sting as, quote, "a year-long prosecutorial Truman Show," a movie I suspect many of you have seen, and they summed up the stakes by saying, quote, "if this evidence suffices, prosecutors would be free to conjure a bribery charge against every politician, ushering in a First Amendment ice age." In the lead up to my sentencing hearing, the court probation officer assigned to research and draft the pre-sentence investigation report wrote, quote, "there are no identifiable victims associated with this case," end quote. And while I agreed with the sentiment, that is a very disorienting thing to hear when you have been charged and convicted of a crime. On the day of my sentencing hearing in October of 2023, the judge handed down a 16-month term of incarceration. This brings us briefly to my imprisonment. And for our time together today, I will simply say that prison is simultaneously awful, it is weirdly fascinating, and if you want it to be, as Rick mentioned, I actually wrote this is one of the pieces I wrote for the New York Times a few weeks back. If you want it to be, it can also be a place of rich community and camaraderie. The hardest part of prison, by far, by far, by far, was being apart from my family, from my wife and our young sons. One of the best, I'll put best in air quotes, one of the best parts of prison was that I quickly became the most prolific maker of cheesecakes on the prison compound, which I will immodestly say were universally regarded as delicious, and you can hit me up later for the recipe. I had been incarcerated for a little over 4 months by the time that oral arguments occurred for my appeal before the U.S. Sixth Circuit. I was not allowed to attend oral arguments and was instead 100 miles away wearing my green prison uniform behind razor wire fences. 6 days later, after oral arguments, a following Wednesday began like any other day in prison. I had a light morning of work for my prison job, which included things like distributing supplies around the compound and getting new arrivals settled in. Late that morning, another prisoner came by my cubicle, studied my face for a second, and said, "You don't know, do you?" "Know what?" I asked. "I just talked to my wife on the phone, and she said it is all over the news back home that the Sixth Circuit is sending you home today," he said. I stood up and hugged the inmate who delivered the news, though I honestly did not actually believe what I had just heard. And then I next took off, literally running in the direction of the prison phone room, where I called Sarah, and when she picked up through tears, she said, "Have you heard?" Most of the rest of the conversation was both of us crying, though I heard her say, "I'm getting in the car to come get you." As is the case with all items of interest in prison, and to be honest with you, a lot of items that are of no interest at all, word spread like wildfire. So guys were coming up to me to say congratulations. A number of guys reached out for a handshake and were very awkward when I then enveloped them in a hug, because hugs are pretty darn rare in prison. And I kid you not, at least 10 guys were like, "Dude, who's going to make all the cheesecake now without you here?" About 5 hours after I first heard that stunning news, I walked through the back door of our house into our kitchen, embraced our two young sons, where the moment quickly turned into a celebration with lots of squeals, shouts, chants of daddy, 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 and a family hug that, true story, even our dog Oakley put her paws in for. Unfortunately, this saga did not end there. The same panel that released me early pending appeal begrudgingly upheld the case against me in a 2-1 split decision in February of 2025 that was extraordinarily unusual in that all three judges, in three separate opinions, said Supreme Court review was warranted and needed. And so the team at Jones Day and I were full speed ahead with our petition for writ of certiorari to the United States Supreme Court. On May 28th of last year, so we're now just a little bit less than a year ago in our timeline, the Jones Day team and I were just days away from submitting our by then completed Supreme Court petition, which was a superb piece of legal advocacy. That afternoon, I was working at home and also getting organized to take my 5-year-old son on a camping trip the following morning. A little after 4 p.m., while sitting at my home office desk, I learned in one of the most surreal moments of my life that I had received a full and unconditional presidential pardon from President Trump. Over the phone, one of my Jones Day lawyers read aloud to me the brief formal verbiage of the pardon. The president had signed the pardon just a few hours earlier, and at 4:16 p.m. that afternoon, I was looking at a scanned digital copy in my email inbox. A pardon was in no way, in no universe on my radar, not because I wouldn't have welcomed one, but because I hadn't applied for one. And I hadn't applied for one because I still believe that the judicial process would deliver justice, even if it took going all the way to the Supreme Court to get it. Sarah was at that point 8 months pregnant with our third son, and she arrived home not long after I heard the stunning news. And I remember walking from my home office to find her in our bedroom, where we embraced, shared what a profound relief it was, especially on the brink of welcoming another baby, and then also agreed what a totally strange event to experience in one's life. I hope all of you are never in a position of needing a pardon, to say the least. The news also fit the pattern that at basically every juncture of this years long legal saga, the wildest and most dramatic thing that could happen did happen. After that latest shocking turn of events, it turned out that our appeal was not mooted. And as I mentioned, I then became the first person known to ever receive a presidential pardon and still be in a position to and to choose to move forward petitioning the US Supreme Court. My feeling was that the stakes went far beyond me, that the consequences touched every candidate and donor engaged in lawful, constitutionally protected political conduct, and that if the misguided charging theory of this prosecution, that lawful campaign donations between donors and candidates who share the same policy objectives, if that can be construed as bribery and is allowed to persist, how many qualified people will be too afraid to ever run for office, and how many citizens who want to support their candidate of choice with a donation will refrain from participating altogether. Now, when the justices of the Supreme Court convene for their conferences to consider cases, it's just the 9 of them in a room together. No aides, no law clerks, nobody else. They took up our petition at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 consecutive conferences. And just 2.5 weeks ago, they unanimously vacated my convictions. In any given year, you can count on 2 hands, and some years just 1 hand, the number of cases where the United States Supreme Court vacates criminal convictions. So it was a wonderful, unbelievably rare, and hard fought victory. We're going to dive into lessons in a minute here. Why don't we take another pause for the third of our QR codes? Rick, I don't know if you need to prompt people.
Yeah, sorry about that. Yes, on the screen now is code number 3372. Please enter that in the Conference IO tracking and for credit for CPE. Thank you. 372. All right, PG, go ahead. Thank you.
Now, what I have just described to you isn't just an extraordinary story where a terrible sequence of events ultimately needed to be corrected by both the White House and the United States Supreme Court. It also illustrates what can happen when intent is misread ambiguity is left unresolved, and decisions are made without enough scrutiny. To be clear, it being a miscarriage of justice that had a profound impact on our family does not mean there aren't things that I would have done differently. So, what are those learnings, especially focusing on learnings that are relevant to you? I'm going to drill down now on 3 points. Point number one, intentions. Point number two, ambiguity. And point number three, fresh eyes. When you're regulating an insurance company, I presume, I know is the case, you know what your intent is. You're focused on ensuring financial health, appropriate market conduct, fair rates and terms, and rooting out risk, including the risk of fraud. So you know your intentions, but do you know the intentions of those you're regulating? This is crucial because only knowing the intentions of half of the stakeholders in any given situation is not the firm ground you would preferably be like to be standing on. Maybe the intentions of those you're regulating are to provide a great consumer-friendly product. Maybe it's to maximize their company's profits, or maybe it's to do something shady. Learning number one today is to fully flush out everyone's intentions. And I like to think of this as 360-degree intention mapping. In the context of the FBI sting operation, I was quite clear about my own intentions. I wanted to support the revitalization of a project that was good for our city. And secondarily, I wanted to be a successful mayoral candidate, including fundraising effectively. I thought I understood the intentions of Ndukwe and his investors and that theirs aligned with mine. But clearly, as you heard in my cautionary tale, don't just assume. Let all parties involved plainly state what their intentions are. Let's say an insurance company submits a proposed rate filing where the same proposed course of action could be motivated by good faith efforts to ensure solvency or by bad faith efforts to price out a segment of policyholders. Do that front end intention mapping and say to your counterparts, can you make clear to me exactly what you're trying to accomplish here and why and how? And answer the same questions for those whom you are regulating. After doing so, summarize and memorialize everyone's articulated intentions and goals in writing, and you can send a follow-up email saying, have I captured this correctly? Some of you might rightly be thinking, well, sometimes people say their intentions are one thing, but really they're another. That's absolutely right. But starting by fully capturing a person's stated intentions will make it that much more evident if there is a gap between their words and their conduct. Again, returning to my case, I would note that my saying, nothing can be a quid pro quo, my words, and then among so many other things, inviting the U.S. attorney to my home with the undercovers reflected airtight alignment between words and deeds. Again, the first key step is to flush out and to map out those stated intentions. Lesson learning number two, ambiguity. The existence of ambiguity in any given situation is not inherently sinister. Ambiguity occurs because we're humans. We can be awkward. We can sometimes communicate poorly or unclearly. But the punchline of lesson number two is that ambiguity is not your friend. It's okay if it exists at some early juncture of a given process, but don't let that process conclude without resolving it and clarifying it. In my case, take the interaction when the appeals judge later characterized Rob talking about campaign donations and me talking about the merits of the 435 Elm project as us talking past one another. Of course, if I could redo that moment, I wish I had said at the time, hey, I just want to reiterate something that I hope I've already made clear. In no way is my support for the 435 Elm project, which I've already been on record as supporting, at all connected or related to any campaign donation that you want to provide. Living that moment in real time, honestly, it didn't seem necessary to me, but saying that would have helped remove any ambiguity that prosecutors would later try to cook me with. I also learned the hard way that the risk of ambiguity sometimes is not just a simple misunderstanding, it's consequences that can be life altering. Let's say a carrier's market conduct exam reveals a pattern of claim denials that are statistically unusual, but not clearly prohibited under the policy language as written. The company's explanation is plausible, but it leaves room for interpretation. Don't let the exam close with that ambiguity unresolved. Whether it's a verbal exchange, then memorialized after the fact, a written exchange, a formal administrative submission, things should be clear and pass the plain English sniff test. If it doesn't, you can say, I could take what you said to mean this, or I could take it to mean that. Can you clarify what you meant? I'm going to say it again. Ambiguity is not your friend. And I think this is important. It's also not the insurer's friend either. Do not just let it be. Lesson number three, in my wife's line of work as a doctor, she's an oncologist. As I mentioned, they call it a second opinion. In some business settings, you would call it a secondary review. Today, I'll be very colloquial, I'll just call it fresh eyes. Again, because we are human, we're fallible. So if someone you're dealing with has murky intentions or some situation you're encountering is ambiguous, you may or may not detect that ill intent, or you might not necessarily see some of that ambiguity. The simplest solution here, I believe, is also one of the best. Institutionalize second opinions and fresh eyes, especially on complex matters, to help avoid ethically compromising situations. I realize and admire and appreciate that you all have specific and technical expertise, but I would also make an argument for second looks and fresh eyes coming from non-experts, or at least from people who don't do exactly what you do all day, every day. They're in certain ways better positioned to account for blind spots and to ask my question from earlier, does this pass the sniff test? In my case, a blind spot was that I was primarily focused on the fact of the 435 Elm project being a home run for the city and for our constituents. I was not reading between the lines about ways in which the undercovers and Ndukwe were attempting to be unsavory, let alone attempting to set a trap. So Rob, trying to conflate lawful campaign donations with my support for the 435 Elm project with vague innuendo, did not register. And another political professional insider type might have also thought, well, Rob's a self-interested donor, nothing unusual about that. But a non-political outsider, honestly, someone like, say, my wife, might have heard Ndukwe's initial comment and thought, I'm not sure you should give him the benefit of the doubt. Or witness Rob trying to offer a campaign donation in cash and thought, something smells off about this. I believe it is relevant and noteworthy that the FBI specifically tried to orchestrate interactions in my case where it would be just me and their undercover agents, so those fresh eyes were not available in real time. Let's say that you have been reviewing a particular insurer's filings for several years and you've developed, understandably, a good working relationship with their compliance team, and things have always been fine. The risk, I believe, is that sometimes familiarity can become a substitute for scrutiny, which actually makes it a great time to have another colleague take a look at a submission that you're about to approve and just again ask some of those basic questions. Anytime that something feels slightly off, but not clearly wrong, is also a great time to trigger a second set of eyes. A final point here on point number three is about sequencing. My getting a second look and fresh eyes far down the road after being indicted, after being arrested, after being imprisoned doesn't do me much good. So ask yourself, do you have a system for second looks baked in before a potential ethical blunder unfolds? So to summarize those three learnings that I've extracted from my case for the purposes of today, it would be this: clarity around intentions, elimination of ambiguity, and second eyes are not just best practices. They are also safeguards against outcomes that none of us could ever expect or anticipate. I appreciate you all inviting me to join you today. Thank you for the important work that you do. If people have follow-ups, you can find me on LinkedIn. I'll turn it back to Rick now, but I'm also glad directly from the audience or filtered to answer any questions. I know presidential pardon, prison, Supreme Court victory. I threw a lot at you, so glad to answer questions about that journey or anything from the learnings that I believe apply to your important work. Thank you all so much.
All right, great. Thank you, PG. So code number 4 is on the screen now. 557 is the code word. Please enter that code into the Conference IO app, and then we will be concluding. You can make sure that you log out or check out from the app once you do that as well. We do have a few minutes. If anyone has a question, For PG, go ahead and submit that in the chat, and we can try to answer those as we go. But
And
um,
Rick, I know we got to get people across the 50-minute threshold too. So I welcome a robust Q&A of anything anyone might have.
all right, I don't see anything popping in yet, but
Give folks a minute.
right. Well, I don't see anything yet, PG. So I guess, well, actually,
I,
all right, I do
I
see a couple. Can you see those questions? I know there's a couple coming in now.
yeah, I saw a few. I'll answer the first two. That I saw. Why was I targeted? As I said, I think the not thought this all came out in public records and court records. The FBI was being, a real dragnet across the whole state, looking for public corruption. They did say I was not a target at the beginning of their investigations. I became a target when Ndukwe, who, as I mentioned, had signed a proffer agreement acknowledging three different felony crimes, became a cooperating witness, at which point it suddenly became much more convenient to say, yeah, I'm paraphrasing here, but like, what about going after Sittenfeld? I also think, and again, I have, family member, friends who work in government. I worked in government, I have great respect for people's government service. This situation that became such a sort of like sequence of errors and system failure. Bureaucracies at their best are fulfilling a noble mission, and I think at their worst can be in self-perpetuation mode of saying, what could I do to justify myself? And I think one thing that happened here is the FBI pivoted from well, it's really important that we go out and stop real crime to saying, we're so desperate to have something to show here that we're willing to try and create a fake crime. The next question I saw was, how did the President of the United States become aware of this case? As I mentioned, we were on the brink of submitting our petition for writ of certiorari, the term when you formally try and get before the United States Supreme Court. I think our being on the brink of that happening there caused the White House counsel's office to become aware of the case. From everything I understand, once they were aware of the case, which they previously hadn't been, they were on the merits deeply disturbed and advanced it to the president for a pardon. Honestly, as I said, my wife was 8 months pregnant. So I was grateful to receive it, but we thought we have as good a chance of prevailing in the United States Supreme Court as any case could. So it wasn't our focus. It wasn't something I'd applied for. We thought we're going to get justice. We're going to get it from the nine justices. It was a real curveball to me that it ended up coming from the President of the United States. Although one little bit of levity here, I'm speaking to you all 2.5 weeks after a unanimous victory with the Supreme Court. And I had one lawyer friend say, all right, the president chucked your case. The Supreme Court vacated your convictions. Two out of three branches of government get Congress to pass a law. Go for the whole trifecta. So, but we were pleased with the outcome. All right, I have since not been able to follow the question. So, Rick, if you want to filter any that have come through,
Yeah, I think great. I think one of them that came through, I think might be a good one is what types of questions do you think would be best to ask to catch someone lying, as you said, saying their intent is different from what it actually is? Any suggestions on what examiners could be considering as they're going through that kind of thought process?
I think, I also like, I do a lot of journalistic work. And one thing they say, sort of in journalism is like, what's the best follow-up question is, why? How come? Can you explain that to me? Like simple, clear things. So obviously it might depend on the given person that's being regulated and what they're saying. I think a lot of what I wanted, and I don't think human beings, to be honest, are people might disagree. I don't think human beings are particularly good liars. So part of what I'm arguing is if you push the person for their clear stated intentions, goals, if there is, not being above board, if there's not candor and honesty, I think it makes it pretty apparent pretty quickly that there's a gap between what's said and what's being done or what's being attempted in other filings or whatnot. So it's more sort of creating that baseline. I guess it would be a little bit circumstantial in terms of what type of questions, but I think basic questions that sort of like the yeah, are the way that I would go. Yeah.
Okay, great.
I just saw, sorry, someone asked if I've read Kafka's The Trial, where a person finds themselves kind of in this murky, unexplainable, unjust battle against the state. And I have, I was an English major at Princeton, but I and others have often described my journey as Kafkaesque, where you're thinking things have felt so upside down from the get-go. So yes, I have read Kafka's The Trial. I would have rather not lived my own version of it myself. But I don't know if you want to lob a couple more from what you've seen.
Yeah, I mean, think there's a few more here that we could just kind of looking through these. A couple
And
of
as
them are
I
just
said,
kind of
if people want
comments.
to, based on both sort of my experience, you all have expertise that I do not pretend to have, but if people ever want to huddle up offline about sort of, putting to practice and distilling a little bit more of lessons and principles I share, I'm glad to do so.
Okay, great. I think we're good then to wrap up here. I want to thank PG for his presentation today, and I also want to thank all of you for joining us. As a reminder, if you submitted a question that wasn't answered, we'll take a look at those and get back to you directly. Please be sure to check out of the app to complete your session. And again, CPE certificates will be emailed in the coming weeks to those who have entered the required number of code words. If you have any questions about that or don't receive a certificate that you're anticipating, please email me and let me know. We can track those down as well. We will be hosting another session in November for our second session of the year. So please look out for the invite for that as well, the date to be determined. Again, thank you for joining us today, and we hope to see everyone again soon. Thank you.